Good morning, sir. Are you James Wheeler?
Yes, ma'am.
And let me get myself up to speed here. Mr. Wheeler is currently on probation in cause number 23 DCCR 1800 for the offense of fraudulent use or possession of identifying information. There was an administrative hearing filed, sent over back in May of 2024, and a motion to revoke that probation filed. Allegations of committing the new offense of public intoxication, testing positive for methamphetamines, testing positive for amphetamines, not adhering to a curfew, being behind in his fees a little bit, and then failing to report for intake in Hardin County. It looks like a recommendation of SafeP after a substance abuse assessment was done on April 16th of 2024 that returned to probation May 7th to discuss the recommendation. Denied using drugs, however, allegedly tested positive on that day. And before the matter could be addressed, left the building. Advised his officer that he was going to make arrangements to go to his own detox program in Austin. Probation said, can't pick what you want to do. And so we're here now with the motion to revoke. Mr. Kimler has filed a motion asking that I set a bond. Mr. Wheeler is on a deferred probation, typically entitled to a bond unless there's certain findings. Actually, this is a straight probation. It's a 2/5. Okay, I've received some information that Mr. Kimler sent over. Do you have an opportunity to review that? Mr. Kimler, you may proceed. Did you want to call your client?
Well, I think I'll let him decide that, Your Honor. Just speaking on his behalf, if he wants to address the court, I'll let him do that. But this is a non-violent offense. My first observation, of course, many times when I move before the court, I know that the state argues the safety of the community is paramount in consideration of the bond. I'm not trying to downplay the seriousness of fraudulent use of identifying information offense, but I would just observe to start with that it's not a crime of violence. Mr. Wheeler's struggled on probation. We want to get him back on track, and as part of that, it would be admission to bond where he could report, continue to work, hopefully not have a positive drug screen so when we come back in front of the court for a disposition of the case, the court's going to revoke him or keep him on probation and be in the best possible position to argue that he should be continued on probation.
Speak up, please.
So that he would be in the best possible position to ask the court to continue him on probation if he would have the opportunity to be in bond, show that he can demonstrate compliance.
Okay, Mr. Nichols.
If he's, whatever bond the court deems appropriate is fine by me, Judge. He just needs to monitor. He needs a drug patch. He needs to be reporting. And seems to have a problem doing those things when he was on probation before. I'll note for the court, on a separate probation, he was sent to safety in 2020.
I saw that.
And obviously it has not worked. So I agree it's not technically a violent offense, but his drug use is concerning, Your Honor.
You want to address the court?
If I may.
Hold on. Raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead.
I have had a history of drug use. When August 4th, my firstborn child was born, and when I heard her cry, I was done. I never touched it again. I put myself in the Franklin house as Lay Manor. I went there for 30 days doing aftercare. CPS was with us up to taking 9 drug tests, negative, and a hair follicle. I'm just ready to provide for my family. And that's why I turned myself in, so I can go back and get this out the way and fixed to where I could go to work, because I couldn't get a job because of the warrant. And I'm really excited to be a father. It's really, I'm trying to put this on the right track so I can get moving.
So one of the things I did get one of those letters is from the caseworker that had some positive things to say. So I'll deal with the bond. I'll set one, but what's the plan? I mean, do we not want to go ahead and go through the motion while we're here, and that way we can then set it for, instead of coming back? So will he waive the formal reading of the motion? So we're going to go through this motion, get pleas of true or not true to those allegations, reset it for sentencing, and then we'll talk about the bond and conditions of that in just a minute, okay? So I have in cause number 23, DCCR 1800, motion to revoke your community supervision. Shows that you were placed on probation March 19th of 2024 for fraudulent use or possession of identifying information. That was a 2-year term in the state jail prison that was probated for 5 years. Is that right?
Yes, ma'am.
It alleges you violated your probation. Count 1 alleges that you committed the offense of public intoxication March 26th of 2024. And is that true or not true?
Yes.
Count 2 alleges that you provided a urine sample April 16th of 2024 and May 7th of 2024 that tested positive for methamphetamines. And is that true or not true?
True.
Count 3 alleges that you provided a urine sample April 16th and May 7th that tested positive for amphetamines. Is that true? I'm sorry.
True.
Count 4 alleges that you were at a location other than your residence at approximately 11:15 p.m. March 26th of 2024. And is that true or not true?
Yes.
True.
True.
Count 5 alleges that you are, as of May 7th, 2024, you were $240 behind in your fees. Is that true or not true?
True.
And then count 6 alleges that you failed to report to the Hardin County Probation Department for your intake on April 9th of 2024. And is that true or not true?
It is true, but hard
True,
to
true with an explanation.
Yeah, we'll get an explanation later. All right, so did you enter your pleas of true to counts 1 through 6 freely and voluntarily? And did you plead true to those counts because they're actually true? All right, then I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true. Find sufficient to revoke your probation. I'm not going to do that. I'm going to reset your case for a sentencing hearing and ask the probation department to do an updated report. And so I'll get a little more information about what's going on. Now, with regard to a bond in your case, I'm going to set a bond at $5,000, but you're going to have a condition of that bond if you make it, that you have to wear a drug patch at all times. You've got to have a drug patch put on within 24 hours of your release from custody. If it tests positive, then you're back in jail and you're off.
Thank you so much.
If there's more, if you have a drug patch that's not testable, I'm going to assume it's positive. So you need to make sure, wear it properly, do whatever you need to keep it on, and go every 2 weeks like you're supposed to get it tested. I think, I don't know exactly what I'll do. I mean, obviously it sounds like some treatment would be required. Wouldn't hurt to go ahead and get started on some outpatient maybe. But we can wait, or you can go ahead, probation's here, and whatever you think is appropriate at this point while we're waiting on sentencing, give those orders and I'll sign off on them.
Yes, ma'am. I was going to give him a new assessment done to see exactly what it is that he needs and get him started.
Perfect. Okay, because it sounds like since the last assessment, there's at least been some treatment, so. Thank you, Ms. Malfino. All right, sir, are you Camden Jackson? And Mr. Harris, will your client waive the formal reading of the indictment?
Yes, Your Honor. And apologies for my handwriting because it's horrible.
It's hard on the tablet. You're good. All right, so you're charged in cause number 25, DCCR 0114, with the second-degree felony offense of engaging in organized criminal activity from January 10th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Harris?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 7-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation, which could include me ordering you to some upfront treatment or like ISF or something like that. And it looks like that's what the state's going to be requesting. Do you understand? And that decision's up to me when we come back for sentencing. All right, Mr. Jackson, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to recite your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Before we go forward, can you look real quick, jail incident reports and see if there's any on this one?
And Judge, I was, if I may, going to address that between January and the end of February. So obviously we've had quite some time that either they have not gotten to my file or the court's file. There were at least 8 pages full of write-ups. I would ask the court, Mr. Jackson committed this offense 6 days after he turned 19. It's obviously very serious. He was with the co-defendant, Mr. Bushnell, who's already entered a plea involving firearms, etc. I would ask if the court would consider your usual admonishment if that behavior continues pending the PSI, that I reserve the right, as does the court, to just reject this offer and possibly send him to prison.
Mr. Jackson, you're probably, I don't know if you're in the same dorm as some of the other ones that have been
Yes.
absolutely ridiculous acting up in the jail. So there's somebody, I think it was last week, that came in with a deal like this for a probation, and he didn't get it, and he's sitting back out at that jail. I do not have to accept this plea agreement. I'm going to read every single one of those jail incident reports. The disrespect that y'all are showing to the officers, I can assume what these are going to say, because y'all are all out there. It's the same group that's doing the same thing, fighting, not following instructions, talking back, calling names. I'm going to read all of that. And let me tell you, if you have one between right now and your sentencing, I will not accept this plea agreement. I'm sick of it. The jail's sick of it. And I'm going to do whatever I can to make that place a better place for those people to go work who are out there just trying to do their job. Do you understand? One. We're not going to come in and say it was somebody else's fault. I only got 1 or I got 3 and that's not that bad. You can go out there and tell them, I want to get out and be on probation. I don't care what you guys want to do. I'm going to behave. If you have to sit on your bunk all day long and be quiet for the next 5 weeks, then that's what you do. Right? 5 weeks, rest of your life. What do you think? Show me you can do it, okay? All right, and go back with the bailiff.
In this intense courtroom moment, a defendant facing multiple probation violations, including drug use, public intoxication, missed reporting, and unpaid fees, admits to every allegation, putting his future on the line. Despite a troubled past and repeated noncompliance, he pleads for another chance, claiming a turning point after the birth of his child and recent efforts towards sobriety. Instead of immediate punishment, the judge delivers a calculated decision, granting a temporary second chance, but under strict zero-tolerance conditions. With a $5,000 bond, mandatory drug patch monitoring, and the threat of instant jail time for any failure, the stakes couldn't be higher. At the same time, another young defendant hoping for probation is hit with a harsh reality check, as the judge warns that ongoing misconduct in jail could destroy his plea deal entirely. This isn't just about past mistakes, it's about proving change under pressure. In a courtroom where every action is scrutinized, the message is clear. One wrong move can cost everything. Now the question remains, will these defendants rise to the moment or fall back into the same cycle that brought them here?